Hey everybody, thanks for joining us. Today's topic is going to be common myths about divorce. All right, so most of my videos, I'll take one topic and I'll do 10 minutes on it or something like that. Right now, I'm just going to do a bunch of small topics, which are still important, but I'm just going to spend a very brief amount of time on them. And again, these are common myths from, my, however long I've been doing this, 15 years of doing divorce work. These are questions I get all the time. And I don't know if there's a lot of junk on the internet. A lot of what you read on the internet is either not specific to New Jersey or it's not written by lawyers. It's written by search engine optimization companies or AI or something like that. And I think that's why there's a lot of misconceptions. So maybe the first myth that we're dispelling here is that what you read on the internet is accurate. It probably isn't, which is why you should watch my videos and give me a call, okay? Because I'm doing my best to tell you what is accurate. So we'll call that the first myth. But the second one is it matters who files first. Okay, some people think that they need to be the plaintiff for some reason, or my wife already filed, now I have to be the defendant, and that screws me over. It does not matter at all. It has zero impact on your divorce. 70% of plaintiffs are women for whatever reason, but that does not give anyone any kind of advantage in the divorce proceedings, because even if you're the defendant, you're going to file a counterclaim anyway, which means that the one party is the plaintiff who filed first, but then you're going to file back, and then you're the plaintiff in the counterclaim. So it does not matter at all. Okay. Number two, that there is some kind of 10-year rule for alimony. I've had people call me and they say they want to get divorced because they're coming up in 10 years and they don't want to get stuck paying alimony. It's like, well, that's not a rule. I mean, I've seen alimony in as little as a 3-year marriage. Now, it's obviously much less and the duration is less. But there's no rule that says you have to get to 10 years. There is a 20-year rule that says if you were married for 20 years, then there's a presumption that any spousal support obligation is going to be open durational, which basically just means you're going to keep paying it with no certain end date. You can watch the video I just did on how you terminate one of those things. Okay, this video called How to Terminate Alimony in New Jersey. When you get to full Social Security retirement age, then you have to make an application at that point to terminate it. But that's the only kind of time-based rule on spousal support. A marriage that's like 6 months or a year won't get spousal support. But when you start to get 3, 4, 5 years, there's going to be a spousal support obligation in all likelihood, but it has nothing to do with 10 years. Okay. Alimony does not necessarily terminate when you reach full Social Security age. You still need to go to court. Okay. I just kind of touched on that. I can't abandon the home because I will lose my equity in the home. Untrue. Your equity in the home was accrued during the marriage. It is assumed, by the way, that when you get divorced, at some point, someone's going to leave the home. Leaving the home does not cause you to abandon equity in it. Now, if you've left the home a substantial amount of time before the filing of a divorce, and you haven't really been contributing to household expenses or anything like that, then you might abandon your additional equity in the home, but you would still have some equity in the home. But if it's a more typical situation where you've got two people living together and then it becomes obvious there's going to be a divorce reasonably soon and one person leaves, they don't abandon their equity in the home. They still have equal equity to the other person that was accrued during the marriage. Okay. It matters whose name the deed is in. Yeah, this is common. I say, what kind of marital assets do you have? And they say, well, I have a home, but that's in my name, and I have 3 cars, but that's all in my name, and the bank accounts, they're in my name. It's like, that doesn't matter. Whose name something is in might matter in other courts of law for other purposes, but for the purposes of a divorce, the New Jersey Superior Court has jurisdiction over all property acquired by the marital estate during the marriage, and the marital estate is either one of you, okay? Whether it's the husband or the wife, whether it's in your name or her name or his name or whatever, if it was acquired during the marriage, it's part of the marital estate. Inheritances are different. I suppose that's another myth. Inheritances don't become part of the marital estate unless they get commingled. But other than that, it does not matter whose name the house is in, whose name the cars are in. If they were acquired during the marriage, they're part of the marital estate. Next myth. This is a popular one. Oh, no. I bought the house. It's my house. I bought it 6 months before we got married. Okay, fine. But that was 20 years ago. All right. You didn't own the house outright. What you did was you bought like a 20% equity interest in the house. But over the course of the next 20 years, you were using marital money to pay down the house. So maybe the judge gives you a little bit of credit for your initial payment, depending on how long the marriage was. The longer the marriage, the less credit you're going to get, by the way. But the payments made into the house, even if it was acquired before the marriage, if you were making payments on it, that's going to count to your spouse's equity, because the money you were using to make those payments, half of that belonged to the spouse. So don't think for a minute that you've like outsmarted the system or something, especially, by the way, if the house was bought in contemplation of marriage. All right. Let's see. Fee per hour versus flat fees. If an attorney is charging you a flat fee for what's going to be a pretty complex case, and it's not like a lot of money, it's like $2,000 or $3,000, you might as well just throw that money in a fireplace. I mean, I'm not talking about a couple kids get married outside, right out of college, and 6 months later they realize it's a mistake and they have no assets or anything like that. That doesn't take a lot of brain power or time to do that. But if you've got a real marriage and you've got real issues you got to determine, that's probably not a flat fee case. You're going to have to pay an attorney by hour, because it's impossible to predict how many hours of work that's going to be. All right. Legal separation. I hear a lot. I don't want to get divorced, but I do want to be legally separated. That is not a thing in New Jersey. There's no such thing as a legal separation. But I'll do a video on some other things that are kind of similar. You can come to terms with a post-nuptial agreement. You can do that, which says that if we get divorced, this will be the date we use for equitable distribution, and here's what everyone's property will be. Okay, that's called a post-nuptial agreement. You can also kind of call it a separation agreement, which is we're agreeing to a trial period of separation now, and this will be the date that we use for equitable distribution, but we're still going to stay married and see how it works. That's not technically legally separated, but you're creating a legal document that's going to be pretty enforceable. And also there's something called divorce from bed and board. And again, that's going to take its own video, but that means you are still technically married, but all of the equitable distribution has taken place. You're only married really in name only. And there's two reasons for that. You have some religious groups that prohibit marriage, and so they'll go for the divorce for bed and board instead. Also, sometimes you can try to keep someone on your health insurance if you do it that way, right? If you get divorced, they will lose health insurance. And so what they'll say is, well, we're only divorcing from bed and board, so we're still technically married. But some insurance companies have gotten wise to that, and they'll terminate the health insurance benefits based on that, which is another myth. I see this a lot. Well, we want to get divorced, but I want to stay in his health insurance. You cannot. Again, maybe through a divorce through bed and board, but you're still technically going to be married then. All right. But other than that, you cannot stay in someone's health insurance once you've been divorced. Let's see. Another one. Emancipation of one child reduces child support proportionately for the other children. Okay, so let's say you got 3 kids and one of them graduates college. And so you think, okay, I was supporting 3 kids. Now I'm only supporting 2. Therefore, my child support obligation should be reduced by 1/3. It actually does not work that way, believe it or not. I don't want to get too much into that, but basically there are certain fixed costs like housing expenses that are considered to be the same no matter how many children there are, or at least they don't shift quite as much as you might think. So the emancipation of one child probably won't reduce your child support obligation by 1/3. The emancipation of one child out of 2 children won't reduce your obligation by 1/2. It'll reduce it, but not entirely. All right. Another myth, the judge is going to make a finding that your settlement agreement is reasonable. No. 98% of divorce cases do not end in trials. 98% end in settlements. But the judge will not read your divorce settlement to determine if it's reasonable or not. All the judge will determine is whether or not you think it's fair and equitable under the circumstances and you want to enter into it freely and voluntarily without duress. But a judge is not going to make any finding of facts other than that. Okay, you will lose half of your worth during a divorce. No, you will lose half of what was acquired during the marriage. Now, I did do a video before on whether or not New Jersey is a 50-50 state. It's not technically, it's an equitable distribution state, but you can lose more than 50%. And what I explained in that video is you're going to lose 50% of the assets acquired during the marriage. But then on top of that, by the way, don't forget, you could have a spousal support obligation. And let's say you have a spousal support obligation of $50,000 a year, which is not uncommon. You make $200,000, wife makes $50,000. Your obligation is probably going to be about, well, in that situation, maybe $30,000 or $40,000, something like that. Well, okay, let's say you're doing that for 15 years. $40,000 for 15 years, that's $600,000. that might be worth more than the entire marital estate. So yeah, maybe you lose $200,000 in equity in your house, but you're losing $600,000 in spousal support payments, which is, more than half the value. So the 50% thing, again, it doesn't affect premarital assets unless it's been commingled. But then on the other end of the spectrum, you can lose 50% plus you can lose more than that when you factor in spousal support and also child support. All right. So you really need an attorney to go through with you what your exposure is and how to limit it in that circumstance. All right. And the last one I want to just touch on very quickly is cohabitation automatically terminates alimony. I did a video recently on how to terminate alimony. I touched on that briefly. Cohabiting, first of all, is not even what you think it is. Cohabiting, you think is your ex is now living with her new boyfriend or something. Well, maybe not. It actually has more to do with how much their economic situation is intertwined. And it's not automatic. You really have to litigate that. You make your motion, you prove to the judge that there is cohabiting and that there's economic interdependence and the extent of it. And the judge can either reduce your spousal support obligation or eliminate it. But there's nothing automatic about it. One last one I see a lot of is adultery. So I'll get people call me and they'll say they want to get divorced and they want to do it on the grounds for adultery. And I think they think that gives them an advantage or something. Or maybe they just want to get divorced and they want me to tell their whole story about how their husband was a bad person or something like that. And the other side caused the marriage to fail. All that stuff is completely irrelevant. I'm sorry if your spouse cheated on you. I'm sorry if you were gaslit. I'm sorry if the other person was completely miserable, put no effort into the marriage, and they are the reason the marriage failed. All of that stuff is irrelevant. And in fact, not only is it irrelevant, you're actually going to cost yourself a lot more money if you plead something like adultery, because now you have to prove adultery. Normally in New Jersey, we're just what's called a no-fault state, which is it doesn't matter who was at fault. One side wants a divorce and that's it. If you want to start proving the other side was at fault for the marriage ending because of adultery, well, now you're going to have to pay your attorney a lot of money because they're going to have to take depositions, gather evidence, and they're going to have to do a trial to prove the other side committed adultery. If you want to see your attorney's fees skyrocket, and your attorney's fees are going to be high enough as it is, if you want to see them skyrocket pretty quickly, that's a good way to do it. I'm sorry that sort of thing happened to you. You didn't deserve it, okay? But it really has nothing to do with the mechanics of a legal divorce, all right? Okay, guys, so those are just some myths. If you have others you want me to address, just put it in the comments and I'll do a second one of these videos, or maybe I'll just do a full video on your question or something like that. Or if you just want to call and you have some other questions for me, go right ahead. I'll be happy to speak with you. Make sure, by the way, if you do that you mention that you got my information from the video, because I like to see who's actually watching these things. All right, guys, thanks for watching. Take care. Have a nice day.